The decision landed on a Tuesday morning. No advance warning, no leaked draft circulating through legal circles the night before, no whisper network of Supreme Court watchers, tipping off the attorneys who would be most affected by what was coming. Just 9 justices, one unified voice, and a ruling that every single person who has ever put a firearm in their vehicle before pulling out of their driveway needs to understand. Before they drive anywhere again, 9-0. Let that number sit for a moment, because in a Supreme Court that has become defined by its divisions, where 5-4 decisions are routine and where justices from opposite ends of the legal spectrum agreeing on anything feels like a minor miracle, 9-0 means something different. It means there was no dissent. No alternative framework being floated by justices who thought the majority got it wrong. No roadmap being handed to lower courts for finding creative ways to limit the ruling's reach. 9 justices looked at the same question, reached the same conclusion, signed their names to the same opinion. And that question directly involves what happens every time you carry a firearm in your car. The case that produced this ruling began in an ordinary way. A traffic stop on an ordinary road in an ordinary state. A driver with a legally owned firearm. A law enforcement encounter that should have been routine. That should have ended with the officer walking back to the patrol car and the driver continuing on their way. Instead, it became the case that traveled all the way to the Supreme Court of the United States. That generated hundreds of pages of legal briefs from some of the most prominent constitutional attorneys in the country. That was argued before 9 justices who then retreated to deliberate and returned with something nobody in the legal community fully anticipated, a unanimous decision with immediate nationwide effect. Here's what you need to understand about why unanimity changes everything in this specific context. When the Supreme Court divides, lower courts have room to maneuver. Dissenting opinions become tools. State legislatures find gaps. Attorneys build arguments from the cracks between majority reasoning and minority objections. The legal fight continues through dozens of smaller battles fought in courtrooms across the country. When the Supreme Court speaks with one voice, that maneuvering room disappears. There are no cracks. There are no gaps. There is only the ruling, applied uniformly, in every federal court, in every state, to every gun owner who carries a firearm in a vehicle anywhere in America. That is the situation as of this morning, and the gun owners who do not know about it yet are the ones most at risk of making a mistake they cannot take back. A mistake made not out of criminal intent, not out of recklessness, out of simple ignorance of a ruling that changed the rules of the road without sending anyone a notice. The changed rules start with 4 words that every vehicle gun owner needs to burn into their memory right now. Jurisdiction determines your rights, not your home state, not the state where you bought your firearm, not the state where your carry permit was issued. The state where your vehicle is physically located. At the moment a law enforcement officer approaches your window determines what rights you have, what obligations you carry, and what that officer is now legally authorized to do when they discover a firearm in your car. That is the core of what the Supreme Court's 9-0 ruling established, and it is a principle that sounds simple until you think through what it actually means for the millions of Americans who cross state lines regularly with firearms in their vehicles. Think about your own driving patterns for a moment. Your commute, your weekend trips, your visits to family, the routes you take without thinking because you have driven them. So many times they feel automatic. Now think about how many state lines those routes cross. How many different legal jurisdictions your vehicle passes through in a typical month. How many different sets of rules about firearm storage, transportation, loaded versus unloaded carry, and documentation requirements apply to your firearm at different points along those familiar routes. Before this ruling, the legal complexity of that situation was significant, but manageable for careful gun owners who did their research. After this ruling, that complexity has a new dimension, because the Supreme Court has now established that law enforcement officers in any jurisdiction your vehicle enters have clearly defined constitutional authority to act on what they discover during a traffic stop based on the laws of the state where that stop occurs, not the laws you followed when you loaded up and left home, the laws of where you are when the blue lights appear in your mirror. The ruling established specifically that when an officer has reasonable suspicion that a firearm in a vehicle may not comply with the laws of the jurisdiction where the stop is occurring, that officer has constitutional authority to conduct a limited search and temporarily seize the firearm while verifying its legal status. That authority does not require evidence of criminal intent. It does not require a complaint or a tip or any prior indication that the driver is dangerous. It requires reasonable suspicion based on the laws of the state the officer is standing in. Here is what creates that reasonable suspicion in practice. A carry permit from a state that does not have reciprocity with the state where the stop occurs. A firearm stored in a location that is legal in your home state but regulated differently in the state. You are driving through ammunition or magazine configurations that are standard in your state and prohibited in another. The attorneys who specialize in Second Amendment law have been on the phone constantly since this ruling came down, not with each other, with their clients, gun owners who are calling with the same urgent questions that every vehicle firearms carrier in America should be asking right now, questions that did not have clear answers before this ruling, and that now have answers nobody is entirely comfortable with. The first question being asked is the most obvious one. What do I actually need to have with me in my car right now to protect myself legally under this new framework? The answer that Second Amendment attorneys are giving is consistent across the board, and it involves 5 specific things that every vehicle gun owner needs to understand immediately. The first is current purchase documentation, not stored somewhere at home in a filing cabinet. In your vehicle, a bill of sale or dealer transfer, paperwork that establishes your firearm was obtained legally through proper channels. This single document does more work in a traffic stop situation than most gun owners realize. It establishes a clean legal origin for the firearm before any other question gets asked. The second is a valid, unexpired carry permit with your current address, current, unexpired, matching your actual address. Any one of those 3 things being wrong creates the kind of documentation gap that now carries real legal consequences under the framework this ruling established. The third is printed reciprocity information, not a screenshot on your phone that you may or may not be able to pull up quickly under stress. Printed, dated, showing the current reciprocity status between your home state and every state your regular driving routes pass through. This document directly addresses the jurisdiction question at the center of the ruling. The fourth is documentation of any training or safety certification you have completed. This is less about legal requirement and more about establishing the profile of a responsible, law-abiding gun owner in the first moments of a traffic stop encounter. Officers make assessments quickly. Documentation shapes those assessments. The fifth, and this is the recommendation that surprises most people when they first hear it, is a brief written statement from a licensed Second Amendment attorney summarizing your legal rights as a vehicle firearm carrier in the jurisdictions you regularly travel through. This document signals immediately that you are informed, that you have sought legal counsel, and that any improper action taken against you will be met with a prepared legal response. Now here is the instruction that every Second Amendment attorney is delivering with equal urgency alongside that documentation list. If a stop escalates anyway, despite your preparation, despite your documentation, despite everything being in order, do not resist. Do not argue constitutional law. The sun came up this morning on a road that looks exactly the same as it did yesterday. Same highways, same traffic, same routine that millions of Americans move through every single day without giving much thought to the legal framework operating underneath it. The same gun owners pulling out of the same driveways with the same firearms they have been carrying in their vehicles for years without incident and without concern. But the legal ground underneath that familiar routine is not the same as it was yesterday morning. And the gap between how familiar everything looks and how significantly the rules have changed is exactly the gap where legal trouble lives, where good people with clean records and lawful firearms find themselves in situations they never anticipated because they were operating on an understanding of the law that the Supreme Court just updated without sending anyone a personal notification. 9 justices agreed on that update, every single one of them. That unanimity is not a coincidence and it is not a formality. It is a signal that the legal framework the court established in this ruling is not a narrow holding that clever attorneys can maneuver around, or that sympathetic lower court judges can quietly limit in ways that reduce its practical impact. It is the law, clearly stated, unanimously supported, immediately effective in every state in America. For gun owners who carry in their vehicles, that law now requires something that responsible ownership has always required in principle, but that this ruling has made urgently practical. It requires knowledge, current, specific, jurisdiction-aware knowledge of the rules that apply, not just where you live, but everywhere your vehicle travels. It requires documentation, organized, accessible, immediately presentable documentation that can establish the legal status of your firearm in the first 60 seconds of a traffic stop before a situation has any opportunity to escalate. It requires preparation, not paranoia, not fear, not a change in whether you carry or how committed you are to your Second Amendment rights. Preparation, the same kind of deliberate, informed preparation that responsible gun owners have always applied to every other aspect of legal firearm ownership. And it requires attention going forward, because this ruling is not the end of the legal story around vehicle firearms in America. It is a new chapter. Lower courts are going to apply it to specific situations, State legislatures are going to respond to it with new laws. Law enforcement agencies are going to update their training and their guidance based on what it authorizes. The road will keep changing even as it keeps looking the same. The 9 justices who agreed on this ruling understood exactly what they were doing. They were drawing a clear line around a constitutional question that had been generating inconsistent answers in courts across the country for years. They drew that line